Ms. Spencer, will you open court, please?
Yes, ma'am. Part 1 of the Chancery Court of Davidson County will now transact the business for which it was created. All persons having business for this court draw near, give attention, and you shall be heard. God save the United States, the state of Tennessee, and this honorable court. Circuit Judge Joseph T. Howell, Chancellor Jera S. Bryant, and Chancellor Patricia Hedmoskel presiding.
Thank you. Good morning, everyone. Welcome to Davidson County Chancery Court, Part 1. We have a hearing today before the 3-judge panel assigned by the Tennessee Supreme Court to hear and decide this case. I'm Chancellor Pat Moskell, serving the 20th Judicial District in Davidson County. Joining me on the panel are Chancellor Jera Bryant, serving the 10th Judicial District in Bradley, McMinn, Monroe, and Polk counties, and representing the Eastern Division of Tennessee.
Councilor Moskell, can you please inform the court that if anybody is looking at the live stream during the hearing, please close off the live stream tab, causing interference with the live stream.
Anyone who is currently on live stream, please close your live stream tab. We're having interference. All right, and also on the panel is Circuit Court Judge Joseph Howell, serving the 26th Judicial District in Madison, Chester, and Henderson counties, and representing the Western Division of Tennessee. As I noted, the Administrative Office of the Courts is live streaming today's hearing, so we ask everyone to be mindful of the live stream as you present your arguments today. Today is Monday, May 20th, 2024. We are here at 9 a.m. Central. The case is called for hearing today on dispositive motions. Our case number 230336, Part 1, Metropolitan Government of Nashville and Davidson County versus Governor Bill Lee et al. And this case is consolidated with case number 230395, Part 3, Part 1. The style of the case is Davy Tucker et al. Versus Governor Bill Lee et al. I'm going to ask one attorney from each set of attorneys to introduce yourself and your co-counsel who are joining you today on this Zoom hearing. First, representing Metropolitan Government.
Good morning, Your Honors. Allison Bussell, the Associate Director of Law on behalf of Metro Nashville. In the room with me, but not on the Zoom, are other counsel that are on our pleadings: John Whitaker, Melissa Roberge, Wally Dietz, the Director of Law, and Bob Cooper.
Thank you very much. Second, representing the individual plaintiffs.
Thank you, Your Honors. My name is Scott Tift, representing the 8 individual plaintiffs who we're referring to as the individual plaintiffs in this matter, joined by separate Zoom channels by Dave Garrison and John Spraggins.
All right, thank you. And third, representing the state defendants.
Good morning, Your Honor. This is Timothy Simons representing the defendants. I'm here with my co-counsel, Jonathan Shirley, who will be participating via another channel.
All right, thank you all and welcome. Today, we are hearing oral argument on the parties' dispositive motions, and we will hear the motions and arguments in the following order. First, we will hear the state defendant's motion to dismiss the individual plaintiff's complaint, and then we will hear the individual plaintiff's response. Second, we will hear the Metropolitan Government's motion to dismiss for lack of justiciability, or alternatively, motion for summary judgment. Then we will hear the individual plaintiff's motion for summary judgment. Then we will hear from the state defendants, both in response to Metro and the individual plaintiffs' motions for summary judgment, as well as their principal argument on their cross motion for summary judgment, as to both first Metro and also as to the individual plaintiffs. Then we will hear the Metropolitan Government's response to the state's cross motion for summary judgment. Next, the individual plaintiff's response to the state defendant's cross motion for summary judgment. And then each each participant will have one round of rebuttal to all other arguments. And I know that may sound a little bit confusing, but I'll try and guide us through the order of the arguments as we proceed. And I just note that because the parties have filed cross motions for summary judgment, which are essentially mirror images of your opposing party's motion, feel free to address all arguments in support of your motion, as well as in opposition to your adverse party's arguments. So in other words, we're suggesting that you do your best not to repeat your arguments. Are there any preliminary matters for the panel to address? Plaintiff, Metro Government,
Nothing from Metro Nashville. Thank you.
individual plaintiffs.
Your Honor, I would just clarify, which hopefully allows for some streamlining here, that on the merits of the legal arguments, the individual plaintiffs are deferring to the Metropolitan Department of Law. As Your Honors are aware, we've incorporated the same pleadings, legal causes of action, and arguments, and are ceding our time to Metro to argue those. And I will clarify, there was a bit of confusion based on how we captioned our dispositive motion and or response about whether there were any parts of Metro's claims that we did not incorporate. The individual plaintiffs did intend to incorporate all of the same claims and arguments, and we followed up with State's counsel after the filings to confirm that that was the case and that they didn't disagree or object, and they agreed. Of course, they fully responded to all those arguments in their consolidated responses. So we, outside of arguing the individual plaintiff's response to the motion to dismiss, you should only be needing to hear from State's counsel and the Department of Law's counsel on the merits claims.
All right, and so noted. Thank you very much, Mr. Tiff. And anything preliminarily from the state?
No, Your Honor.
Okay, very good. Then we are ready to proceed with the first motion, which is the state defendant's motion to dismiss the individual plaintiff's complaint. You may proceed, Mr. Simons. And before, I'm going to interrupt before I even let you start. I understand Carol Briggs is our court reporter today. I do not see a tile for her on the screen, but I'm going to ask Miss Briggs if for any reason she is unable to hear or is having any difficulties that she interrupt, and please let us know. Thank you. All right, Mr. Simons.
Good morning. May it please the court. My name is Timothy Simons, and I, along with co-counsel Jonathan Shirley, serve as counsel for the defendants in this consolidated action. We're first addressing the defendant's motion to dismiss the complaint filed by the individual plaintiffs due to lack of standing. And we submit in our filings that the individual plaintiffs do not have legal standing to challenge the constitutionality of Chapter 21 of the 2023 Public Acts, which I'll refer to as the Act, in this case, and therefore their complaint should be dismissed under Rules 1202 and 1203 of the Tennessee Rules of Civil Procedure. And as I mentioned, the essence of the individual plaintiff's complaint is they're challenging the constitutionality of the act under Article 7, Section 1 and Article 11, Section 9 of the Tennessee Constitution. And their complaint alleges substantially similar, if not identical, claims that have been asserted by Metro Nashville in their complaint. And as alleged in the complaint, the individual plaintiffs are all registered voters in Davidson County, and based on their written responses to our motion to dismiss, it's our understanding they're now relying on their status as voters as the sole basis for claiming that they have standing to bring their action. But contrary to the individual defendant's position, they have not suffered, nor will they suffer any injury sufficient to establish standing to challenge the constitutionality of the act under any theory in the complaint. Therefore, we think their complaint fails to state a claim under Rule 12. And as the court knows, in Tennessee, standing is a judicially created doctrine that focuses on whether a party advancing a claim is properly situated to prosecute the action. And when considering whether standing exists to bring a constitutional claim, a court must focus on the party bringing the lawsuit and not the merits of the underlying claim. And to establish standing, a plaintiff must assert and show three elements. One, a distinct and palpable injury, that is, an injury that is not conjectural, hypothetical, or predicated upon an interest that a litigant shares with the general public. Two, a causal connection between the alleged injury and the challenged conduct. And three, injury must be capable of being redressed by a favorable decision of the court. And it's our position, pursuant to our motion, that the plaintiffs cannot show a distinct and palpable injury recognized under Tennessee law that would give them standing to challenge the constitutionality of the act. So I'm going to focus the arguments on the allegations that these individual plaintiffs, that voters have standing to bring this action. As I mentioned, standing may not be predicated upon an injury to an interest that the plaintiff shares in common with all other citizens or all other voters. And as mentioned, that standing alone as a voter does not provide the legally acknowledged palpable injury that would give them the standing in this case. And instead, as this court ruled in its temporary injunction order back in April of last year, the individual plaintiffs, quote, alleged injuries appear indistinct from the sorts of generalized grievances of all citizens. And that was at page 16 of the temporary injunction order. And we submit that ruling is appropriate and, based on the case law in Tennessee, justified dismissal of the individual plaintiff's complaint. Now, in their response,
Mr. Simons, let me
Yes.
just interrupt there just as
Sure.
a point of clarification. That this court did enter a Rule 65 temporary injunction, and what the court can continue to adopt the findings of fact and conclusions of law. Those are also subject to being revisited because it was an interlocutory order. And so if there's any additional arguments that you want to make, my point being, I encourage counsel to address all your arguments and not to presume that the findings made at the temporary injunction stage are conclusive and final on any particular issue. So excuse the interruption. I just wanted to clarify that.
and Your Honor, I didn't mean to imply that. My point was that we concur with the ruling, the finding that the court made in that order. That was
Understood.
that's
Thank you.
consistent with our motion. Now, in their response to our motion to dismiss, the plaintiffs argue that they based their standing argument on the premise that, quote, the Constitution provides an express right to vote related to the act. And they argue that Article 11, Section 9 of the Tennessee Constitution, quote, bestows an express right to vote on a county's residents with respect to the local legislation. And the court cite, or the individual plaintiffs cite, a couple of constitutional provisions to base that statement on, and we respectfully disagree. They specifically mentioned the local legislation clause, that's Article 11, Section 9, Clause 2, as arguing that the express right to vote related to the act is contained there. And we would respectfully disagree with that. If you look at this particular clause, the local legislation clause, it acknowledges no guarantee that a voter would have a right to vote on any kind of local informal effect legislation. We take the position that this is a law of general application and therefore doesn't violate that. But with regard to the standing analysis, if you look at that constitutional provision, it says there's no guarantee of an individual voter to right to vote, but depending on how the legislature enacts the law, either it can be approved either by the legislature, by the 2/3 vote of the local legislative body or by a majority of the electorate. So obviously that provision does not provide an absolute right for a voter to vote on a particular matter. And we think that is another indication that this is more of a generalized grievance that doesn't, it's not predicated on an express constitutional right. The court, may it please the court, the individual plaintiffs also cite the consolidation clause, which we'll get into in the summary judgment motions, which is Article 9, Section 9, Clause 9, that talks about the process for consolidation which what happened in 1962 when the Metro Nashville consolidated to become a metropolitan government. But obviously we respectfully disagree. There's no express right to vote granted in that to the individual plaintiffs in this case, particularly because that deals with a right to vote of voters to approve the consolidation, which happened 60-something years ago. But it does not confer on an express right to vote on any matters that are addressed in this act, which is in essence the implementation of certain caps on the size of metropolitan government councils. So we don't think that creates an express right that would give them the specific injury argument that would allow them to have standing. And then lastly, they cite Clause 7 of Article 11, Section 9, as arguing that this creates another express right to vote, that gives them standing. And we respectfully disagree with that, because if you look at the language of the clause they cite, that specifically mentions those legislative bodies that are covered under home rule municipalities, and not a situation where you have a consolidated government that has adopted home rule. By the provisions of the constitutional clause there, it's limited to municipalities that have adopted home rule. And in Tennessee, based on the latest count, there's about 12 municipalities in Tennessee that have adopted that. And it is just inapplicable to the argument that the individual plaintiffs are making on this. So we think in the totality of the circumstances and looking at the assertions made by the individual plaintiffs regarding what they claim is their particular injury or grievance that gives them standing, we think the case law coupled with the constitutional provisions that they've cited do not support their argument, and in fact shows that this is more of a generalized grievance, which the law does not allow the individual plaintiffs to rely upon to come into court to challenge this act. And so we would respectfully request that the court grant our motion to dismiss and dismiss the complaint of the individual plaintiffs. Thank you.
All right. Mr. Simons, I've got a couple of questions, and then
Sure.
I'll ask the other judges if they have any questions as well. So I take it from your argument that your position is under Article 11, Section 9, that Clause 7 and Clause 9 of that constitutional provision are mutually exclusive, that Metro generally comes within Clause 9. It does not come within Clause 7 because it is a consolidated government and not a municipality. Is that your position?
Yeah, well, Your Honor, as I was mentioning, I think Clause 7 does not include metropolitan governments. That was my position. Yes.
Any metropolitan government, not just
Yeah.
Metro Nashville, but any consolidated form of government.
Well, it relates to municipalities, consolidated municipalities.
Right. And I'm just trying to pin you down that if it's a consolidated government, it comes within Clause 9, not Clause 7, correct?
That's correct.
Okay. The other question that I had is in terms of evaluating this generalized grievance, what is the comparator? In other words, do we just look at Metro Nashville voters within the consolidated government, or do we compare them to all Tennessee voters? This is an act. The act is a statewide act. And so the potential pool of voters who might bring a claim, whether they have standing or not, but who could potentially bring a claim to challenge the act are statewide voters. But in this case, we just have voters who are residents of Davidson County. Does that change the analysis at all on the generalized grievance point that you make?
Sorry, Your Honor, I didn't mean to speak over you. Respectfully, no. Regardless of whether you look at this as a right of action or an argument that whether the voters of the state of Tennessee or the individual voters in the metro municipality or government would be entitled to vote on this, the application of the rules and the legal analysis would have the same outcome, namely that if relying upon just a general alleged right to vote, if it's not a constitutional right granted that the individual plaintiffs are attempting to argue, that it's going to be a generalized grievance that otherwise does not infringe upon any voter rights, and therefore merely being a voter doesn't allow you standing.
Thank you.
Thank you.
Chancellor Bryant, do you have any questions?
I'm hearing your argument, but aren't you using the term municipality to mean two different things? Because it appears that part of this talks about a home rule municipality versus a city.
Your Honor, I think I'm sorry, I didn't mean to interrupt. Well, I think it talks about home rule municipalities in this provision, Your Honor. And as I mentioned, there's 12 of those in Tennessee.
Okay. All right, thank you.
Thank you.
Judge Howe, any questions for Mr. Simons?
Not at this time. Thank you, Chancellor.
All right. We are ready to proceed then with the response on behalf of the individual plaintiffs. Mr. Tift, you may proceed.
Your Honors, my name's Scott Tift, and may it please the court. I do represent the 8 people being called the individual plaintiffs here, and these are 8 voters in Davidson County, 4 sitting council members, several faith leaders, other community leaders that at the earlier stage of this litigation before the court's injunction, Mr. Simons sort of referenced this, there were other potential grounds for standing, including whether or not the council members' terms were going to be extended or not, whether or not campaigns were going to be upended since the election took place as it was originally scheduled. That's why we are now focused not on those grounds, but on only the grounds of these 8 individuals as regular and active voters. And Your Honors, the particularly important difference here to many cases that concern generalized grievances challenging governmental action is that this is one of the few situations in our Constitution where the framers of the Constitution bestowed a right to vote to citizens on government action. I don't claim this to be an exclusive list, but looking through myself, I believe there's only a handful, 5 or 6 similar situations. Whenever new counties are to be created, Article 10, Section 4 provides for the popular vote for that. Whenever the Constitution is to be amended, Article 11, Section 3 provides for the popular vote. Whenever the credit of a county is to be extended, the popular vote is required, Article 2, Section 29. And then in the Home Rule Amendment, which is located at Article 11, Section 9, focusing on first here on the local legislation clause, as everyone here is well aware, the local legislation clause states that any act that has local effect on, in this case, a county, shall be void and of no effect unless the act by its terms either requires the approval of a 2/3 vote of the local legislative body of the municipality or county, or requires approval in an election by a majority of those voting in said election in the municipality or county affected. Now, this, as I've just pointed out, is rare. Most of our government action happens through the legislature without any express popular approval mechanism included in the Constitution. And most of the generalized grievance case law, including all that's been cited either by defendants or in this court's original order, is outside of the context of a constitutional grant of the right to vote. And what we want to say at the front end, and I know Judge Howell wasn't with us in the previous stage of this litigation, due to this case being filed subsequently to the Metro case and the time for consolidation. At the original hearing, plaintiffs had not been able to brief this issue, had been raised by defendants. So the case law I'm about to talk about wasn't raised at the injunction stage by defendants, plaintiffs, or the court. And we maintain that the Supreme Court's case in Walker v. Dunn is precedential in this case, that when the Constitution grants a right to the populace to vote on governmental action, plaintiffs have standing. In Walker v. Dunn, which was back in the 1970s, the Congress of the United States had proposed the 26th Amendment, which would lower the voting age to 18. And our Constitution, at Article 2, Section 32, says that when Congress proposes an amendment, it shall not be ratified or voted on until either a constitutional convention or General Assembly elected after that proposed amendment has been proposed to the states. And what happened there, our General Assembly was in recess when this amendment was proposed. And our General Assembly called a special session within days of its proposal to ratify the amendment. And then citizen voters of the state of Tennessee filed a lawsuit saying that violates our constitutional provision that an amendment can't be ratified until the next General Assembly. The question of standing was directly raised, and it was directly argued that voters don't have standing to challenge this government conduct. And the Tennessee Supreme Court said that yes, voters do have standing because the claim sounded in the voters' quote, indirect right to vote on the ratification through their vote for their legislatures, and then confirmed that the averments are sufficient to satisfy the requirement of special injury or real interest in the suit. So again, in that case, while of course, it's not a long case, not a lot of detailed discussion, the court expressly states that voters had standing there, even though Article 2, Section 32 doesn't actually state anything about the popular vote. It just talks about the next General Assembly. But the Supreme Court went ahead to confirm that this was the holding, and that is the point about 30 years later in ACLU versus Darnell. One of the cases that's been cited in this case to suggest that the plaintiffs here, individual plaintiffs, don't have standing. But in that case, the Supreme Court actually differentiated Walker in a way that shows that these individual plaintiffs do have standing. In ACLU versus Darnell, there was a proposed state constitutional amendment that gets to the ballot through legislative action and then is voted on by the people. And voter plaintiffs challenged the placing of that amendment on the ballot, claiming that the legislature didn't follow the proper procedures to place that amendment on the ballot. And those voters were determined, since voters do not have a direct role in determining whether an amendment is placed on the ballot, that they were merely asserting a generalized grievance against governmental action. Those plaintiffs had said, well, look to Walker. And so the Supreme Court differentiated Walker and noted that in Walker, the special session of the General Assembly back in the 70s had, quote, deprived the voters of their right to vote for the General Assembly that would be charged with ratifying the amendment, and differentiated that case by noting that standing was, quote, predicated upon a distinct, concrete injury in fact, denial of the right to vote. And that's the situation we're in here. The state's response, as I've heard, is not that where the Constitution grants a specific right to vote on governmental action, there's no standing. The state's response seems to be that the local legislation clause does not grant a right to vote to individuals. And we submit that it does grant that right to vote in situations where the act does not include a provision for local government approval. Again, the local legislation clause makes legislation with local effect void and ineffective unless either subject to approval by, in this case, the Metro Council or the populace of Davidson County. This act, everyone would agree, does not include a provision for Metro Council approval, and therefore the voters here have been denied their right to vote on whether or not to approve this allegedly local legislation. This is actually clearer language than the language at issue in Walker. Again, the language in Walker doesn't mention the individual vote, whereas the local legislation clause does specifically provide for local approval of legislation in cases where the local legislative body has not been provided the opportunity to approve the act. And therefore, because that right has been denied here by not being included in the act, these individual plaintiffs and all voters within Davidson County have a specific injury in the deprivation of their right to vote. We submit that Walker, as confirmed by ACLU versus Darnell, is precedential here and requires, given our Constitution's grant of the right to vote on this type of government action to voters, that it requires finding that the individual plaintiffs do have standing. And we note, while that's precedential, we've also pointed to at least one persuasive law case from the state of Michigan in a similar situation where it's called, it was in a footnote, Save Our Downtown versus City of Traverse City, Michigan Court of Appeals, 2022. In there, the city charter required voter approval for any building to be built over 60 feet tall. The Planning Commission then approved a building over 60 feet tall. Voters sued to challenge it, and the Michigan Court of Appeals expressly determined that standing did exist because where there's specific voter approval included in the governing document, in this case, a city charter, that bestows standing and is not a generalized grievance because the actual right to vote is being denied. Now, looking to the more common generalized grievance case law, I would point first to one case that this court cited in its injunctive order, which is cited perennially in cases trying to decide about generalized grievances, and that's the case of United States versus Hayes, which is a U.S. Supreme Court decision in the racial gerrymandering context. Now, it's important to understand the facts of that case, and the facts are that it was alleged that one of the districts was a racial gerrymander that was being challenged, but notably, the individuals challenging that district did not live in that district. So those voters outside of the district could only allege a generalized challenge to governmental conduct because they were in no way injured by a different district's alleged racial gerrymander. That injury would fall to the voters within the allegedly racially gerrymandered district. The parallel here, as Chancellor Moskal sort of asked a question about, is the other 94 counties in Tennessee have millions of voters, actually, all of whom were they unhappy with the Metro Council Reduction Act, and if they thought it was an affront to the Home Rule Amendment, would merely be asserting a generalized grievance by saying, we believe that violates the local legislation clause and we want to challenge it, but they would not be individually hurt because their locality would not have been affected by local legislation. The one county of Davidson County is the county where the individuals have a specific injury, again, an injury of their right to vote. In the section about voter standing, the defendants cited just 3 cases, all generalized grievance type cases. One we've already talked about, ACLU versus Darnell, another Parks versus Alexander, are both questions of how a constitutional amendment got to the ballot in the first place. And again, voters do not have they don't play a role in determining whether a constitutional amendment gets to the ballot. That's the legislature that does that through successive sessions of the General Assembly. And there, voters challenging the placement of a ballot of an amendment on the ballot were determined to be merely asserting a generalized grievance against government conduct and therefore didn't have standing. The third case cited by the defendants was City of Memphis versus Hargett, which really affirms the fact that where voters have the right to vote, infringing that vote does give standing, because in that case, which challenged the photo ID requirement for voting, the 2 individuals who brought that case were found to have standing because they alleged they had had their right to vote denied when they showed up without photo IDs. And of course, it's been long held through our case law that infringing the right to vote is ample for standing. The city of Memphis got dismissed for standing there, but the individual voters didn't. And again, here, the individual plaintiffs are individual voters with the constitutional right to vote. I think it's also important to note that the fact that voters share their injury with some other people has never been a reason for dismissal. In pretty much all of at least the redistricting context of cases like US v. Hayes, everyone within a district shares the injury. If you're in a racially gerrymandered district, or that's what you're alleging, you and the other voters within that district share an injury, and that shared injury is different from a generalized injury with people around the whole state. And then finally, in this court's injunctive decision that opined that there was a likelihood of not having standing, the court cited two cases in addition to US v. Hayes, Hamilton versus Metro and Monsieur versus Haslam. Hamilton versus Metro is a citizen of Metro concerned that the Metropolitan Council did not put a council seat up for a special election. And again, that is not an act on which voters have a right to participate. The legislature itself, in this case, the council, has the right to set or not set special elections as they will. And therefore, a citizen challenging that decision only asserts a generalized grievance against governmental action. And then in Monsieur versus Haslam, an individual hoped to be placed on the ballot for an appellate judgeship and challenged the fact that under the Tennessee plan, he could not be placed on that, but he again would share that grievance with anyone around the entire state who wanted to be placed on the ballot. And while judgeships under the Constitution do have to be elected, the method of the election can and will be set by our legislature, which set ours, as we know, through retention elections in the Tennessee plan. And so this is not a case of a generalized grievance. This is a case of one of our 95 counties having citizens who are challenging an act that has, they allege, local effect upon them. And the local legislation clause gives citizens of a county the right to vote to approve or reject local legislation unless there's a provision allowing for the local government to do so. Were the Metro Council given the right in this act to vote up or down? I think it would be a much closer question about if citizens also have the right to vote there, but that is not the case. By its clear terms, there is no local government approval mechanism in the act. And therefore, the citizens who brought this case have the right to vote under the Constitution, and that right has been infringed. And therefore, the Walker case is precedential, given that where the Constitution provides citizen approval as a mechanism, standing is then, individual voters do then have standing. The final point I would point out, which is a step back a little bit, is as we know, in 2018, our legislature did pass what's ultimately, I believe, an amendment to the Declaratory Judgment Act in passing Tennessee Code Annotated 13121. We noted that this section is pled in the complaint, noted in our response that this, while we believe that Walker is the precedential case and the analysis stops there, by passing 13121, the legislature created a cause of action for any affected person who seeks declaratory or injunctive relief in any action brought regarding the legality or constitutionality of a government action. Now, we would submit where our Constitution has recognized a right against local legislation for 60 years now, that this creation of a cause of action further demonstrates that those affected, is not the whole state, but just the citizens in Davidson County, would also have standing even if they didn't have the right to vote. Because it's very clear, and this has been briefed throughout the merits part of this litigation, that the Home Rule Amendment was created to stop what had been a lot of local legislation passed by the legislature. And so now for more than 60 years, that has been a recognized injury. And while a cause of action under standing law can't create out of nowhere standing just by creating a cause of injury. It can demonstrate standing where the right has been long protected. And so even if we weren't in a situation where these individuals have a right to vote, we submit that the creation of that cause of action in 2018, paired with the more than 60-year-old right against local legislation, would also give the citizens of any county affected by local legislation that would validate their standing. And so I will stop there subsequent to any questions and ask that it be determined that the individual plaintiffs here as voters of Davidson County in a case alleging local legislation against Davidson County be deemed to have standing and allowed to proceed to the merits of the case, which, as we stated, we will defer to the Metropolitan Department of Law to argue.
All right, thank you. I'm having a very noisy HVAC unit here in the courtroom, so I'm had to mute myself. I apologize. Chancellor Bryant, do you have any questions for Mr. Tift?
Not on this issue.
All right, Judge Howe.
Not at this time. Thank you, Chancellor.
All right, very good. And so at this time, I want to make sure, Mr. Tift, and just confirm again that you are not pursuing claims on behalf of the individual plaintiffs in their capacity as candidates or incumbent council members post the
Correct.
2023 election.
Correct, Your Honor.
All right, thank you. All right, any rebuttal, Mr. Simons?
Sorry, Your Honor, I keep hitting the unmute button. Yeah, I just will be very quick, Your Honor, because I know we need to move along to the summary judgment motions. I would respectfully reiterate that we don't believe the constitutional provision cited by Mr. Tift provides that express right to vote that he's relying upon and arguing that Walker v. Dunn applies. And if you look at the Walker v. Dunn case, I think it's distinguishable from the present case in that in the Walker v. Dunn case, the relevant constitutional provision was Article 2, Section 32 that dealt with ratification of constitutional amendments. And that provision specifically required a ratification vote and gave the right to vote. And the issue was it had to be, the vote had to take place and had to be taken by a convention or the General Assembly that was elected after it was submitted. So, I mean, that's a constitutional provision that does grant an express right, and it's baked into the provision and the procedure that the Walker v. Dunn was pointing out had not been complied with. So I think that's a different scenario than what we have here. And so we respectfully request the motion to dismiss be granted.
All right, thank you. I don't have any further questions. Chancellor Bryant?
Nothing.
All right, and Judge Howe?
Not at this time.
All right, thank you. We are ready to proceed now with our motions, cross motions to dismiss, and we will first hear from Metropolitan Government on its motion to dismiss for lack of justiciability or alternatively summary judgment.
Thank you, Your Honor. May it please the court. Allison Bussell, Associate Director of Law on behalf of Metro Nashville. I'll begin with just a short summary of the argument and then a brief review of what the act does, and then I'll dig into our substantive arguments after that. While this lawsuit originally raised complex constitutional questions, the case can now be decided on straightforward justiciability grounds. The Metro Council Reduction Act sets a 20-member cap on the size of metropolitan councils as further provided in the act. The only portion of the act that this lawsuit challenges as unconstitutional is the mandate to reduce Metro Nashville's council size. That is subsection 1A of the Act as implemented through 1B. State defendants concede that 1B can no longer be implemented. So that mandate to reduce is no longer an issue in need of a resolution. And because courts should address constitutional issues only when absolutely necessary, this lawsuit is now moot and the court should so hold. But even if the court were to proceed to the constitutional issues, the case can be easily resolved on the local legislation clause claim alone. Given this, I plan to limit my prepared arguments on the constitutional claims to the local legislation clause claim in count 2 of the amended complaint. I'm certainly happy to answer any questions the court may have about the other constitutional claims, but otherwise we will rest on our briefing. As to the local legislation clause claim, defendants effectively concede that subsection 1B is unconstitutional, nor could the state have argued otherwise, given that 1B set forth an insanely expedited process for reducing council size that applied only to Metro Nashville. Importantly, subsection 1A's cap on council size is not self-executing, and instead, by its plain language, turns on that timeline in 1B. As a result, 1A is not severable from its unconstitutional counterpart 1B, and the mandate to reduce Metro Nashville's council size in subsections 1A and B must both be enjoined. Before we dig into these arguments, I want to briefly review what the Act does and how we got here. This lawsuit challenges the constitutionality of 2 provisions in the Metro Council Reduction Act, which is 2023 Public Chapter 21, namely subsection 1A as implemented through 1B. Those subsections collectively create a mandate on Metro Nashville and only Metro Nashville to reduce the size of its council to a number of districts no greater than 20. In all of their briefing, state defendants take the position that subsection 1A says that, quote, the membership of a metropolitan council must not exceed 20 voting members, period. Here's the problem. That's not what 1A says. It says the membership of a metropolitan council must not exceed 20 voting members, comma, as further provided in this section, end quote. And then subsection 1B that follows sets forth a very specific process requiring Metro Nashville, only Metro Nashville, to adopt new council member district boundaries with no more than 20 districts in time for the August 2023 general election. More than a year ago, we appeared before this court to argue that the act should be temporarily enjoined, given the likelihood of success on the merits and the act's expedited timeline that would have caused significant irreparable harm in Metro Nashville. The court agreed, enjoined subsection 1B of the act pending a decision on the merits. The qualifying deadline for the General Assembly's targeted August general election was May 18 of 2023. This court ruled on April 10, more than a month before that. But state defendants did not seek expedited review of that ruling. As a result, the implementation mechanism timeline set forth in 1B expired on its terms. And state defendants now concede that the challenge to subsection 1B is moot because all of the deadlines have expired. That takes me to Metro's first substantive argument. The Council Reduction Act no longer mandates a reduction to Metro Nashville's council size, so the constitutional issues in the amended complaint are moot. Metro Nashville's mootness argument turns on the plain language of the act, plain language that state defendants repeatedly ignore. Subsection 1A sets a cap on council size as further provided in this section, meaning section 1 of the act. Now, state defendants argue that 1A itself sets a cap on all existing metro governments and that 1B merely imposes additional requirements on those councils that have more than 20 members. The problem with this argument is twofold. First, that's not what it says. If you were setting a cap on council size at 20 members, you would cut the sentence exactly where state defendants keep cutting the sentence in all of their briefing. You would put a period where the comma is and be done with it. And then you would list the other requirements after that. That's of course not what the statute does. It says the membership of a Metro Council must not exceed 20 voting members as further provided in this section. Let's contrast that language with Section 2 of the Act, which applies to municipalities and sets a cap on municipality legislative body size. Section 2 of the Act in subsection A1 says, after the next general election for the governing body of a municipality held on or after the effective date of this act, the governing body must not be composed of more than 20 voting members, period. Not as further provided in this section, but period. In A2, it says, with respect to municipalities formed after the effective date of the act. So future municipalities, the governing body must not be composed of more than 20 voting members, period. Not as further provided in this section, but period. The second problem with the state's reading of the language is that it would render multiple other provisions within Section 1 of the Act meaningless in violation of statutory interpretation principles. When interpreting a statute, a court must presume that all of the words have a specific purpose and meaning. If state defendants were correct that subsection 1A sets a standalone cap, then the qualifier as further provided in this section would be entirely superfluous. You'd accomplish the same thing if you just struck through the entire phrase. And this is bolstered by the fact that Section 2 accomplishes exactly what state defendants are suggesting, but without that qualifying language. That is, Section 2 sets a cap on existing and future municipalities in the first subsection, and then in the following subsections outlines what municipalities must do if their legislative bodies exceed that cap, with no qualifying language to connect the subsections. Subsection 1C of the Act would also be rendered meaningless under the state's interpretation. That subsection sets a cap on council size for future metropolitan governments. If the state were correct that subsection 1A sets a standalone cap on all metropolitan councils, there's no need at all for a provision that says, yes, this applies to future councils too. Again, you'd accomplish precisely the same thing if you struck through the entire phrase. Now, state defendants' argument that Section 1 creates a distinction between existing metropolitan governments in 1A and 1B and future metropolitan governments in 1C is more consistent with the Act's plain language, but it still misses the mark. That reading fails to account for the qualifier as further provided in this section. This section means all of Section 1, all of the remaining subsections, B, C, D, and E. This interpretation is also consistent with use of the term this section in subsections D and E, which address the fact that certain things are not preempted so long as that cap is still effectuated. Again, the only reading of the statute that marries all of this language without rendering any of it meaningless is one that treats the rule in A1 as qualified by the subsections that follow it, with each of those subsections setting forth the circumstance, a different circumstance in which the cap may arise. But even if the court were to adopt the state's interpretation, that is, that A and B go together to cover existing metropolitan councils and C addresses future metropolitan councils, that does not yield the conclusion that 1A creates a standalone cap on council size. And here's why. In this argument, defendants are effectively conceding that A and B are married to one another, that A and B go together to address what happens for existing councils that exceed, for existing metropolitan councils. The as further provided language merely underscores that relationship between the two. The court's role is to apply the act's plain language to effectuate the legislature's intent. The qualifier as further provided in this section must mean something. And state defendants have offered no explanation for what that language could mean that isn't already accomplished by other language in the act. The rules of statutory interpretation do not permit the level of contortion that the state's argument requires to make this make sense. The cap in subsection 1 is subject to the subsections further provided in that section. And subsection 1B is the only mechanism further provided in section 1 that mandates Metro Nashville to reduce the size of its council. And having agreed that 1B is now moot because the timeline has expired, state defendants effectively concede that it is now too late to mandate that reduction. One side note, none of the charter provisions that the state defendants cite in their reply brief give Metro Nashville the ability to alter its council size by ordinance. Even the Metro Charter Act requires council size to be set by charter, and there is zero support for the state's position that Metro Nashville can just pick another number legislatively, as opposed to having to go through the charter amendment process. Subsection 1B1D would have given Metro Nashville the ability to do that differently, but again, that subsection has expired. The General Assembly did not build that broad authority into the entire act by making it its own subsection. Instead, it buried it in subsection 1B, which applied only to Metro Nashville. And absent 1B, the act crumbles underneath itself. In the end, because subsection 1B is the only mechanism for mandating a reduction to Metro's council size, and that provision is now moot by the state's admission, the act no longer mandates that reduction. This court should address constitutional issues only if necessary. In fact, the Owens case that we cite in our briefing says only if absolutely necessary. And here, for the reasons I've argued, those issues no longer need to be decided. This court can and should hold that this lawsuit is moot. That takes me to our second substantive argument. If the court were to proceed to the constitutional issues, this case can be easily decided on the local legislation clause claim alone. Two of the claims in the amended complaint are now moot as a result of the timeline in 1B having expired. Those are the Ripper Bill claim in count 2 and the Article 7, Section 1 claim in count 3. Both of those claims addressed the alteration of council member terms in the act, and that's just an issue that is no longer live as a result of the general election having occurred on its normal timeline. So that leaves 3 of Metro Nashville's original claims for consideration: the Consolidation Clause claim in count 1, the Local Legislation Clause claim in count 2, and the Article 7, Section 1 exemption claim in count 4. Again, we will rest on our briefing for all but the Local Legislation Clause claim unless the court has questions about the others. As this court is aware, the Local Legislation Clause prohibits legislation that is local in form or effect and applicable to a particular county in its governmental or proprietary capacity unless the act contains language requiring local approval. As to this claim, state defendants have not disputed that subsection 1B is unconstitutional. Metro Nashville argued in its motion for summary judgment that 1B was local in form or effect in violation of the local legislation clause. The state defendants did not respond to or otherwise refute that argument, nor could they, given 1B's obvious application to only one metropolitan council. Instead, the state focused its entire argument as to subsection 1B on its purported severability. Keep in mind, however, defendants aren't simply arguing that 1B is severable if unconstitutional. They are arguing affirmatively that 1B should be elided from the act. Elision is utilized for unlawful provisions. We've identified no authority to support a court eliding a statutory provision simply because the timeline in that provision has expired. The court would be redlining large swaths of the Tennessee Code if that were in fact required, as timelines in legislation expire all the time as a matter of course. Instead, the implication of state defendants' argument that 1B should be elided is that 1B is unconstitutional. And it is unconstitutional, given the state's failure to refute that argument in response to our summary judgment motion, and in the reality of subsection 1B's mandate applying only to Metro Nashville. As a result, the record is undisputed that 1B violates the local legislation clause. So that then leaves the question of whether 1A can be severed from its unconstitutional counterpart, 1B. It cannot. Elision is not favored under Tennessee law, and provisions in a statute are severable only if the statute's legislative intent can be maintained without the provisions. In fact, the court may not conclude that the legislature would have enacted the act without the objectionable features unless that conclusion is made, quote, fairly clear of doubt from the face of the statute. And that's the Davidson County Elrod case, Tennessee Supreme Court, that the state defendants cite in their briefing. Under the plain language of this act, legislative intent requires that 1A and 1B be read together. Again, subsection 1A is not a standalone provision, and it does not contain a standalone cap. I don't want to beat a dead horse here, but it is very important that that provision contains a qualifier by setting the cap as further provided in this section. That qualifier does not exist in section 2. Those words must mean something. And state defendants have offered no plausible explanation that 1A would establish a standalone cap that would not already be accomplished by other words in the statute, and that would not be accomplished by simply striking straight through the qualifier altogether. That's actually a nice segue. State defendants don't just argue for the elision of 1B. Of course, they agree 1B's moot now, strike through the whole thing. They also argue for elision of the qualifier as further provided in this section. They ask the court, redline through 1B and also strike through the qualifier. This position is fatal to the act, and here's why. This argument is spelled out on pages 5 and 6 of the state's reply brief. They first argue on the bottom of page 5 that this language, meaning as further provided in this section, may be elided from section 1A along with 1B. And then in support, they cite Tennessee Code annotated 13110, which allows a court to sever discrete sentences, sections, clauses, parts of a statute if the code would otherwise be unconstitutional or ineffective if you left them in. Okay, so here would be an example of that. Say the court strikes a provision of the code as unconstitutional, And there are other provisions of the Tennessee Code that refer back to that provision or perhaps turn on its language. This statute gives the court the ability to elide those provisions as well, because they don't work the same anymore. They have a different impact or perhaps no impact because of this unconstitutional law. That's what the state defendants are arguing here. 1B is unconstitutional, and because 1A refers to 1B through the language as further provided in this section, then you just elide through the qualifier too. Listen carefully to what they say on page 6 of their brief. The language as further provided in this section, in section 1A, would be rendered ineffective by the elision of section 1B. This language may therefore be elided along with 1B. Let me say that differently. If you delete 1B, which you have to because it's unconstitutional, then you also need to delete as further provided in this section because it won't mean anything now. Let that sit for a moment. They are arguing on one hand that 1A and 1B are not inextricably intertwined, that they are not severable, that you can still enforce 1A without 1B. But then they're arguing on the other hand that as further provided in this section has to be redlined along with 1B because the one won't mean anything without the other, that you can't enforce 1A as written without 1B. Those positions are irreconcilable. Subsection 1A cannot create a standalone cap on council size, but also contain language that is rendered ineffective by 1B's removal from the statute. If 1B turns on language in 1A and defendants have now told you that it does, then 1A is necessarily not severable from 1B. Elision cannot frustrate the object of the legislation, and the state cannot delete language from an act merely to avoid its consequences. And that is precisely what the state is asking this court to do. The only way for the phrase as further provided in this section to be rendered ineffective by 1B's unconstitutionality is if the two provisions are interdependent. And if those provisions are interdependent, then severability is necessarily inappropriate. The court must interpret a statute to effectuate the legislature's intent. And the state of Tennessee has effectively conceded that 1A and 1B rise and fall together. The court can and should find in Metro Nashville's favor, even if on this point alone. Subsection 1B of the Metro Council Reduction Act is unconstitutional, and there's been no argument presented otherwise. Because 1A is not severable from 1B, as state defendants have effectively conceded, then the court must enjoin it as well, insofar as it mandates a reduction to Metro Nashville's council size. I'll conclude with this. Metro Nashville's challenge to the Council Reduction Act no longer requires the court to pass over complex constitutional issues. This case can and should be decided on justiciability grounds. We would ask the court to enter an order holding that subsection 1A of the Act, as implemented through 1B, no longer mandates that Metro Nashville reduce the size of its council, because those are the actions that this lawsuit challenged, the only actions that this lawsuit challenged, then the constitutional issues no longer need to be decided. The court should so hold, dismissing the lawsuit on mootness grounds. But even if the court were to address the constitutional issues, the case should be decided on the local legislation clause claim alone, again, consistent with the constitutional avoidance doctrine. Wading into other complex constitutional issues is not necessary, certainly not absolutely necessary, and when it's not necessary, it is not advised. Defendants concede an inextricable connection between 1A and 1B by arguing that the phrase "as further provided in this section" is rendered ineffective by 1B's unconstitutionality. In other words, 1A is not severable from 1B as applied to Metro Nashville, and the two must fall together. Should the court proceed to the constitutional claim, we would therefore ask the court to enjoin 1A as implemented through 1B. Thank you. And
Thank you.
I'm happy to answer any questions.
All right. Chancellor Bryant, any questions?
Yeah, I want to go back to, I think it's Article 11, Section 9, and address what you said just briefly about the way a charter can be amended, and look at the part where it says that the absent the General Assembly creating a charter commission, that your local municipality can create a home rule by, excuse me, not home rule, but can amend by ordinance.
Are you, Chancellor, are you in paragraph 6 of the amendment? I know they're not numbered, but that begins with "a charter or amendment may be proposed."
Yes.
Okay. If you'll give me just 1 second to read that provision. So I think the answer that sticks out to me, Your Honor, is that this paragraph is addressing home rule municipalities, which the Metro Nashville is not a home rule municipality. We are, of course, a type of home rule, as the Jordan v. Knox County case describes consolidated governments. And so therefore, we would fit into the consolidated government provision in paragraph 9. I would also, and I'm not sure if this is where you're going, but your question led me there, so I'm just going to say it. I would also add that we aren't suggesting that a charter amendment couldn't be proposed in Metro Nashville. What we're saying is a charter amendment can't be forced on Metro Nashville. There is no mechanism in the Metro Charter for altering council size legislatively. So the council can't just choose to do that on its own accord. It would have to go through the regular charter amendment process, which is outlined in the Metro Charter. And of course, the only mechanism for altering the Metro Charter in Nashville is to do that by referendum. So all that could happen is essentially a request to the voters. But the court wouldn't have the authority to require the voters to adopt it, and the court doesn't have the authority to just rewrite the charter. And so, again, I think what this argument highlights is that the purpose of the act was always to require this to be done a particular way, the way outlined in B1, because that's where the legislature gave Metro Nashville broader authority than it currently has in its charter. It gave Metro the right to alter council district size by legislation, even though its charter said otherwise. And of course, its charter says it's done by charter because the Metro Charter Act says it's done by charter. The legislature didn't put that provision in a standalone subsection of the act. It buried it in B1. And so we would argue that that really just bolsters the concept that the General Assembly wanted this to be done a particular way, as further provided in this section, and they accomplished that by expanding that authority within B1 itself.
Thank you.
Judge Howe, any questions?
No, I think I understand Metro's argument.
All right, very good. And I don't have any further questions. So we will proceed with the state's argument, or excuse me, let me back up. Mr. Tift, I understand from your opening remarks that you adopt Metro's argument, but let me invite you, is there anything that you wish to add that is particular to the individual plaintiffs?
No, Your Honor, we incorporate and defer to Metro Council.
All right, very
Department of
good.
Law.
Thank you. Mr. Simons, you may present on behalf of the state.
Thank you, Your Honor. Let me first say that with regard to the issues that Ms. Bussell has addressed, I will address the motion to dismiss as well as the summary judgment arguments that she put forward to the court on the local legislation clause. But we will also defer to our briefs on the other ones for the sake of proceeding. But I will say, as far as our motion for summary judgment, we've sought summary judgment, a dismissal of all claims filed by the individual plaintiffs as well as the Metro government. And we think we're entitled to summary judgment on all claims, and we would rest on those briefs. But let me address these issues Ms. Bussell has brought up. First, I guess the motion to dismiss on mootness grounds. We dispute that this is now a moot matter. Although Ms. Bussell says that we've admitted that certain provisions of the act are unconstitutional, as the court's aware, when we came into court in April of last year, we defended the entire act as being constitutional. We put forward arguments to the court, and to the extent we did not appeal the preliminary injunction order, and as time has gone by, because the deadlines have passed, this issue of whether 1B is now moot. We do acknowledge that because of the timeline that's been passed, that the issue of constitutionality of 1B is now a moot question. However, in us acknowledging that, we in no way have stipulated as to its unconstitutionality. But the question remains, now that it is moot, does that somehow bolster the argument by Metro Nashville that now the entire constitutional dispute as to whether Section 1A is unconstitutional is also moot? And we disagree with that. We think that there's still a justiciable controversy regarding Section 1A and its enforceability as applied to existing Metro governments, as well as 1C, which I don't think is being challenged by Metro Nashville, but it's part of the statute that's being addressed. So in response to the question of whether the whole matter is moot, I think you need to go and look at the analysis that Metro Nashville has asserted as to why they think it's moot. And obviously the position they've taken is that because the provisions of 1B now are basically ineffective because the time has passed, therefore 1A is inextricably connected with that. We don't dispute that 1A and 1B are related, but we do not believe that they're inextricably interwoven to where they cannot be separated for purposes of elision and supporting and affirming the mandates set forth in Section 1A. And as we think the issue that you have to keep in mind, Your Honor, we talk about rules of construction, we talk about the rules that apply with regard to constitutional challenges. The overwhelming objective that the court must follow is trying to ascertain the intent of the legislature. And we think our position on that and how we've construed 1A and 1B and 1C, it furthers that and is supportive of the legislative intent and that Metro Nashville's proposed construction does not. The way we see it, Your Honor, with 1B now moot, we have 1A that still is effective, that still applies to all existing Metro governments. And keep in mind, we're not talking, Metro Nashville is only one of three that are in existence that 1A would apply to. And you have 1C, which talks about all Metro governments that may come into effect in the future, and it imposes the cap on that. So we respectfully disagree that 1A cannot be enforced as a standalone provision, even with the provisions of 1B not being effective now. because of the passage of time. And I think that's the only one that's consistent with the idea of what did the legislature intend to do here? What did they do? And remember, this is a statute. You have the section 1 and the section 2. The legislative intent was to impose a cap of 20 members on the bodies of metro governments throughout the state and municipalities throughout the state. And there's hundreds of municipalities that will be governed by section 2. So you have to look at this in totality of the circumstances and the totality of the act, and not take piecemeal views of various snippets of different rules or different provisions in the statute. So I think in view of that, and the view of what the legislature was intending to do here, it's quite clear that 1A is a standalone provision, even without 1B. Now, Metro Nashville says, well, but if you take out 1B, there's no enforcement mechanism. There's no way to ensure that Metro Nashville will comply with this provision. And we also, on that point, as we point out in our brief, respectfully disagree to that. The mere fact that there's a statute that says all metropolitan governments in existence must have no more than 20 members on their legislative body. That is enforceable by other remedies, statutory and common law, and we cite to a myriad of different statutes that deal with the idea of enforcement of law. And there are statutes throughout the code that have mandates for action to be taken or for compliance to be maintained that don't have self-enforcement mechanism, but that doesn't prevent the use of these regular remedies that are available, including mandatory injunction and or mandamus, or all of those that are there for that very reason, to ensure that the law is complied with by governments. So the argument that Metro Nashville asserts that somehow because 1B is no longer effective because of all that somehow they are not bound by the law. And we respectfully disagree with that and state that the law, it says that under 1A, they shall maintain and shall reduce their metro council size to 20. So I think that's one of the bases they've asserted for why this is not enforceable and why it's now moot is just not a valid argument. Now, with regard to the constitutional question, because 1A is still in play, and we contend that 1A is fully constitutional and is not violative of the Tennessee Constitution, that the motion to dismiss that Metro Nashville has filed should be denied because what is the passage of time for Section 1B does not resolve that question. So we would respectfully ask that the court deny the motion to dismiss filed by Metro Nashville on the mootness grounds. Now let me get to the next question, which is raised about the local legislation clause and how this claim relates to 1A. And as we've mentioned, and this relates to the whole concept of mootness, if 1B is not at play, then can 1A stand alone? And we submit that it can. And the way we view it is 1A applies to all existing metropolitan governments, 1C to all future ones. And clearly the not having 1B in the mix now certainly does not undermine the fulfillment of the legislative purpose through 1A and 1C. Now, with regard to the arguments about the local legislation clause, the Ripper bill argument, I think Ms. Bussell said, is really not pertinent now because of the 1B not being effective because of the passage of time. But 1A, if you apply the local informer effect arguments that were raised by Metro Nashville to somehow say that 1A is not effective under that provision of the Constitution, clearly it does pass the local legislation clause. It is a law of general applicability that applies to not only Metro Nashville, but two other ones. And also, although the other two municipal governments, consolidated governments, are in compliance now, as the Burson case says, the Tennessee Supreme Court in Burson acknowledged that it does affect those other two in the sense that they have to maintain compliance with those statutes. and therefore it is a law of general application, and therefore is constitutional. Metro Nashville also discusses the concept of the doctrine of elision, and we point out in our briefing that even if the court somehow views Section 1B is still in play here, under the doctrine of elision, that the court can strike 1B from the statute and to allow 1A to remain in place and 1C. I would like to point out just generally, I think it's important for this analysis because Metro government talks about different rules as to why the Section 1A and 1B should fall together. And I think that misses the mark on what the court's supposed to do in analyzing the constitutional questions here. And I think, as we point out in our brief, there's a strong presumption of constitutionality, and every doubt should be resolved in favor of the constitutionality of the statute. And therefore, elision can be a tool to carve out any provisions that the court believes are unconstitutional to maintain the integrity and the enforceability of the remaining provisions of the act. And I'll mention, when you're talking about how Metro Nashville and our construction of the statute is at odds, I think you need to look at which construction being proposed to the court harmonizes the additional provisions that are in the statute, excluding 1B. And I think the state's position is clearly the one that the court should adopt. But as was said in by the Tennessee Supreme Court in the Bayless versus Knox County case, the court said, because courts have a duty to save, and insofar as constitutionally permissible legislative enactments when a statute is susceptible of two constructions or interpretations, one which will preserve the statute and one which will destroy it, the court must adopt a construction that will preserve the legislative enactment. So that's contrary to Metro Nashville's position. Ours harmonizes these and allows an enforcement of the remaining provisions of the statute that promote the legislative intent. So under our argument, from this point forward, you've got a 1A that imposes this on all existing metropolitan governments, 1C on all future ones. So all the provisos and scenarios are covered with regard to the coverage of the statute. Excuse me. So contrary to Metro government's position on that, there is no ambiguity or lack of effectiveness with regard to the applicability of the remaining provisions. And it's also important to point out with regard to this legal challenge brought by the individual plaintiffs and Metro government, that they've in their complaint have alleged that this is facially unconstitutional and that their claims are based on an allegation of facial unconstitutionality. And then it's important to point out with regard to the Tennessee case law on that, that this presumption of constitutionality is even greater force against allegations that something's facially unconstitutional. In fact, in the State v. Crank case, Tennessee Supreme Court 2015, the Supreme Court said that a facial challenge is, quote, the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exist under which the act would be valid. So in essence, and then also in the Lynch case that we cite in the case, it says to prevail on a facial challenge, a party must demonstrate that the statute cannot be constitutionally applied in any circumstance. So in light of those very high bars, Metro Nashville has not met those. And obviously with regard to the enforcement of the act and the interpretation of it, the construction proposed by the state is clearly supported by these rules that I've just mentioned to the court, as far as affirming whenever possible and under any circumstance the constitutionality and effectiveness of a state legislative enactment. So clearly, there's really only one proposed construction that meets that test, and it's the defendants in this case, their construction. the question begins with regard to the local legislation clause, as we mentioned in our brief. Local legislation clause, if a statute is a law of general application, then the constitutional provisions requiring local elections or voting on it do not apply. And so this is a law of general application applying just to not only Metro Nashville, but other metro governments. Therefore, it does not run afoul of the local legislation clause. And so that obviously the defendants should prevail on the claim that it is violative of the local legislation clause. And then lastly, with regard to this issue of elision, I think it's important to point out that this rule, this doctrine is flexible, and it's used on a case-by-case basis for particular circumstances before the court on any given case. And it's that flexibility that the court, in conjunction with this mandate, common law mandate to uphold the constitutionality of the statute whenever possible, those two interconnected principles, when you apply it to the case here, clearly mandates that 1A be affirmed. And to the extent that this provision that Ms. Bussell referred to as further provided in this section, I think you missed the boat by focusing on as further provided in this section to say somehow that makes 1A and 1B completely interrelated and they must fall together. I think that's inconsistent with the spirit of the rules and the case law that we've cited, where you try to promote the constitutionality and affirm it whenever possible. So we think that is not a appropriate argument in support of the complaint. The other point I was going to mention, this issue of ratifying the charter, and to the extent, you know, what can they do or not do? Sure, there's a provision in 1B that talks about them being able to amend their charter, but there are other ways to do that. And I'll offer this, which we did in our brief, Your Honor. Clearly, if the court finds that this act, including 1A, is an enforceable legislative mandate that's not constitutionally objectionable, then clearly that would be the supreme law, and it would trump anything that's in their charter to the contrary. So one of the arguments would be, and in there, as we point out in our brief, section 305 of their charter has basically a severability clause. Section 1430, I'm sorry, where it severs from the charter any invalid charter provisions. I would submit that it's not even required for them to do a charter amendment, because if this law is in effect and it's effective, they're bound to follow it, and there would be no requirement for them to even do a charter provision. But as Ms. Bussell said, they do have a mechanism and could do that if necessary, but I don't think it's necessary based on the fact that this is the law of the land, and to the extent that there's a charter provision that is contrary to that, it would not be effective, and that the statutory mandate would be the effective provision. So that was an issue that was discussed as to what's the effect with 1B, 1D not being available if the entire provision is elided from the act. So in essence, may it please the court, we submit that the constitutional claims that have been asserted by Metro government and the individual plaintiffs that include the local legislation clause, the consolidation clause, as well as the other ones that have asserted, we addressed all those in our brief. We think that it's clear that there is no legal basis for those claims, and they should be dismissed on summary judgment in favor of the defendants. And I'm available for any questions, Your Honor. Thank you.
All right, thank you very much. I wanted to start with a question as to your last point. The as further provided in this section
Yes, Your Honor.
Phrase in 1A. What is the state's position as to what this court does with that phrase? We can't just ignore it. It is in the plain language of section 1A. And so what is your position as to how this court should treat that phrase in ascertaining and effectuating the legislative intent of the General Assembly.
Well, I would think, Your Honor, that to the extent, if the court feels that that provision there somehow needs to be elided for purposes of 1A being enforceable, then the court should do that. I think in light of the situation and the way that 1A reads with 1C, that clearly to the extent that this would create any kind of dispute as to the coverage, the court, and in light of the legislative intent to impose the mandates for these Metro Council membership caps, that the court could certainly elide that from, in addition to 1B. And with that being elided, which I think from our briefing and the cases we show, is certainly possible to support the legislative intent. So,
Are there any cases?
Sorry,
I'm sorry.
go ahead, Your Honor.
Are there
Thank you.
any cases of which you're aware where the court has not only elided a section of a legislative enactment, but has them elided or redlined a phrase that's in a different section?
Well, I would suggest, Your Honor, that
Chancellor
That's getting
Michael,
to some pretty fine-tuned.
I'm so sorry
red
to
line.
interrupt, but Judge Howe appears to have disappeared from the screen.
sorry.
So I wanted to alert you before you
Oh,
kept
Sorry.
going down.
Sorry.
I
I'll mute
had not
myself until we
noticed,
get
so
back
thank you
on.
very much. We'll
Currently,
pause for
I'm
just a
on the
moment.
phone with Judge Howe, so we're trying to get him back online. So Chancellor Mosca, it's up to you whether or not if you want to continue or have a 5-minute
We're
recess.
going to pause for just a moment, and if it would be helpful,
Yes.
Mr. Williamson, perhaps we could take a 5-minute recess for everyone to reconnect with Judge Howe.
Thank you. Thank you.
All right, we'll be standing in recess. Thank you.
Okay, I can see somebody. I can see a gentleman, Judge.
Oh, no, I think my laptop is.
I can see a Timothy somebody.
Hold on.
Okay, everybody, I'm about to bring the judges in within the next 30 seconds. I'm about to bring the judges in within the next 30 seconds, and we will begin session.
All right, I think we have everyone back. Both with audio and video, so we're ready to proceed. I was attempting to ask a question of State's Counsel, and I'll see if I can repeat that. I'm not sure that I can. What I was asking about is under 1A regarding the phrase as further provided in this section. If we sever and elide 1B, what do we do with that phrase in 1A? And I believe your suggestion was that we should also elide that phrase from 1A. And I was asking, are you aware of any cases that have done that pinpoint elision where the section, I mean, we're editing the General Assembly's language, essentially, and where the section remains, but we're going to elide a portion of it. And I just was curious as to whether you have any examples of any cases that suggest that that's appropriate.
Your Honor, the only cases that I'm aware of are cases that cite to the general severability statute, which is Tennessee Code Annotated 1-3-110, and that have followed that. And if you look at the actual statute 110, it allows a broad latitude in what you can elide from a statute. If you look at it, it says, I'll just quote it, "It's hereby declared that the sections, clauses, sentences, and parts of the Tennessee Code are severable, and that any of them shall be extended if the code would otherwise be unconstitutional or ineffective." So I think if the court somehow felt like that provision potentially rendered 1A ineffective, it could be elided with 1B to maintain that idea that we think is the correct interpretation of the act, that 1A provides a general cap for all existing metropolitan governments and 1C for all future ones. So I think there is statutory authority for being able to, elide that as further provided by the court.
But your research hasn't revealed any specific cases that have done that, is that?
No, other than just cases that recognize the authority of the courts under that statute, Your Honor.
All right, which then that brings me back to your argument that 1A is a statute of general applicability. We've got 3 current metropolitan governments in Tennessee, consolidated governments in Tennessee. Metro being the only one that exceeds the 20-member cap as set forth in 1A. The other 2, one has 15, I believe, and the other maybe 20.
That's correct.
I may have misspoken, but I think that's right. And so I go back to Ferris versus Blanton, which is the leading case on the Home Rule Amendment regarding general applicability. And it says Within the framework of the test here and above announced, we must determine whether this legislation was, quote, designed to apply to any other county in Tennessee. But in determining potential applicability, we must apply reasonable, rational, and pragmatic rules as opposed to theoretical, illusory, or merely possible considerations. And so in thinking about these other two consolidated forms of government and what would have to occur for them to come out of compliance and be subject to this provision, they would have to go through a process of amending their charter or governing document to increase their size of their legislative body and have that approved in whatever manner is provided under their legislative body for this cap to apply to them. And I'm just, because of the number of steps that would have to occur and the machinations of being potentially applicable to them, I just want to make sure that we've fleshed out what would need to occur and does it meet this test as set forth in Paris. I know that was a very long question and I apologize, but I think hopefully you got the gist of what I'm asking about.
Well, Your Honor, I think metropolitan governments amend their charters from time to time. So, metro government has amended its charter. So these are possibilities, likelihoods that could happen in the future. But I think you need to read, Your Honor, in all due respect, the Ferris and the Burson case together. Burson is a later case that kind of pronounces these rules that we're talking about with a little more clarity as far as what is generally applicable. Now, the Burson case stands for the proposition that, as you know, in that case, there were three civil service boards, and there was a statutory enactment, and there was Knoxville, Memphis, and Nashville. And two of the three, the Nashville and Memphis, were already in compliance with the statutory mandate, but Knoxville was not. And Knoxville tried to argue that this was really applicable to us because the other two are in compliance, and therefore it's targeted to us, and therefore it should violate the local legislation clause. But in Burson, the Supreme Court acknowledged that this potential law of general applicability not only applies to ones that have to engage in some action to come in compliance, but also applies to those other municipal governments, consolidated governments, or whatever entity you're talking about in the statute. They have to maintain compliance, and that requirement to maintain compliance with that is enough to satisfy the test as to whether the statute is generally applicable. And like you said, we're not talking about just one metropolitan government. We have three in the state. We could have more, and also it's possible that there'll be additional metropolitan governments that could happen in the future. This statute applies, to not just the ones in existence. 1C also applies to the future.
But we're not concerned about 1C. That 1C is not being challenged in this lawsuit. That pertains to future metropolitan governments, and I, certainly see your point as to future metropolitan governments, but that's not what we're being asked to decide. It's only the constitutionality now of 1A, and which is existing. And in thinking about what those other consolidated governments would need to do, it just raised that question for me. But thank you. I think I understand what your position is under Burson. One thing that I also had a question about and would invite you to address, and I'm going to have the same question for Ms. Bussell, is that at the temporary injunction stage, the Metro did not pursue seeking injunctive relief under count one of their amended complaint regarding the consolidation clause. And that, and I know that you relied on your briefs, but I just wanted to invite you, is there anything that you would like to address with respect to the consolidation clause that perhaps we have not considered since we didn't address it on the temporary injunction stage?
Well, sure, Your Honor. I mean, we briefed it in quite a bit of detail in our summary judgment submissions, but I would say that I guess the argument, if you crystallize it down, is Metro Nashville is taking the position that because they, became a metropolitan form of government and since 1962, that there was some kind of compact under these constitutional provision that's cited that would bar the state from making subsequent legislative enactments that might affect some of the charter provisions, as long as those statutes are generally applicable. And I think, as we said in our briefs, and we cited the Chattanooga-Hamilton County Hospital Authority versus Chattanooga and the County of Shelby versus McWhirter cases, I think they stand for the proposition that with regard to consolidation, the mere fact there has been consolidation, as long as it's a statute of general applicability, that in the future, the legislature can make enactments that may affect a change in the underlying charters, and that doesn't run afoul of the consolidation clause argument. Now, the other thing is, Your Honor, is with respect to that, we cited in the Metro Nashville's own charter that they envision potentially there could be subsequent legislative enactments, and also we cite provisions in Title VII that deal with charters that show that these charters that are put into effect, that are enacted pursuant to the consolidation statutes, it is envisioned that potentially other future general laws could affect them in some way or could force them to make a change. And I think ultimately the mere fact that this allows for consolidation does not strip away the authority of the legislature to make subsequent legislative enactments that could cause a change, as long as those statutes are of general application.
It's not limited, though, to the original consolidation. It says, and governmental and corporate functions now are hereinafter vested. I want to make sure I understand your argument, and I did read your briefs.
I'm sorry.
And there was a lot of reading involved, and so I just want to see if we can't get to the bottom line and make sure I understand what your position is. So you're saying that this constitutional provision does not prohibit the legislature from passing statute acts that impact the consolidated form of government or its functions. And that's in the first clause of first sentence of paragraph 9. But then it goes on to say, such consolidation cannot become effective until submitted to the qualified voters residing within the municipal corporation and the county outside thereof. It's talking about the consolidated government, and approved by a majority of those voting. So you're saying that second provision applies only to the original consolidation?
Your Honor, if you could direct me back to which provision you were citing.
I'm sorry. I'm at Article 11, Section 9, Clause 9, the very last clause. And there's two portions of that clause separated by a semicolon. And so I'm just asking what your reading is of that second clause. Are you reading that to apply only to the original consolidation vote?
I'm not sure I understand the question, Your Honor. I think with regard to the prohibitions or the restrictions that this constitutional provision establishes, I don't think that it limits the legislature's ability, as was stated in the Hamilton County case, to go in and modify or actually to rescind the government, the form of government. I was going to point to a citation in the Hamilton County case. Bear with me, Your Honor, I'll find it here.
All right.
That would require a referendum vote of the populace. But the Supreme Court, page 327 in the Hamilton County Hospital Authority case, said that a referendum vote is only required for acts that accomplish a consolidation, not for acts amending or repealing a consolidation. So I would say that to the extent that these caps on the metro government are amending in some respect the charter, the consolidation, the form, that it would be permissible.
But then does that implicate the exemption clause that we've also not talked about in understanding how these constitutional provisions interrelate, which is Article 7, Section 1, Clause 2, where it addresses the legislative bodies of counties. And it says the legislative body shall not exceed 25 members. And any county organized under the consolidated government provisions of Article 9, Section 9 of this Constitution shall be exempt from having a county executive and a county legislative body as described in this paragraph. And as described in this paragraph with regard to the legislative body is the 25-member cap. And so does that conflict with the act as provided, imposing a 20-member cap? This says 25 members and then exempts consolidated government from its provision.
Yeah, well, Your Honor, I think I follow the rationale of the court in its temporary injunction order, where it said that this provision doesn't apply to metropolitan governments.
And Metro has made a contrary argument in its briefing, and I just want to invite you to address that if you have anything further to say.
Well, as it's stated in our brief, Your Honor, this doesn't apply to Metro Nashville. It's because it doesn't apply to metropolitan governments.
So you're saying that the whole clause, just the legislative body clause of Article 7, Section 1 is not applicable.
I'm saying the 25-member cap that's set forth in this constitutional provision does not apply to Metro government. Metro
All right.
Nashville.
I just wanted to make sure you had an opportunity to address that, and I'm going to ask the same question
Sure.
of Metro. And then my last question, and I'll turn it over to my colleagues. We made findings of fact in that temporary injunction, and under Tennessee Rule of Civil Procedure 65.047, we can adopt those as findings of fact on the merits. I don't know whether we will or not, but we can. So are there any findings that you disagree with or dispute for purposes of any merits decision?
No, that's a fairly broad question with
It is.
regard to everything that's in the order. I would say, Your Honor.
Well, we had a specific section on findings of fact, and that's what I was referring to, which is at pages 6, 7, 8, 9, 10, and part of 11. So I know that's a lot,
Yeah, Your Honor,
but I'm curious as to what the party's provisions are. And if you're not prepared to address that specifically, that's fine. We may invite you to review those.
Your Honor, I would request, we would be glad to submit to the court, if the court wants to make that request for us to respond specifically to the findings, we'd be glad to submit that in a later.
And I'm
submission.
not sure all of them are material or relevant to the merits,
I understand.
particularly those that pertain to Section 1B regarding the upcoming election and some of the findings that were directed to the potential harm
And as
to
I'm sorry.
Metro.
And I will just say, as the court knows, we submitted our own proposed statement of undisputed material facts, and we'll rest upon those, but we'll be glad to respond to any ones that were, if the court wants to hear specific responses to those in the injunction.
I just wanted to make sure that we had that, if something had jumped out to you that was inaccurate, that you had the opportunity to address those. And as I understand your all party statements of undisputed material facts, none of them are disputed. The only issue is materiality based on the parties' respective positions. And I see everybody nodding, so I think we're confirmed on that.
Yes, Your Honor. We disputed some of the facts that were asserted by the other parties as to whether they were material or not. But other than that, I think most of the facts are undisputed.
That was our reading. Okay, thank you. All right, Chancellor Bryant, I'll turn to you.
In looking at TCA 1-3-110, I think you can boil it down to, we should use the severability statute or the doctrine of elision if to take out this phrase, if it would otherwise be unconstitutional or ineffective. Is that your argument?
Yes, Your Honor.
So it's your position that 1A would be ineffective if we did not sever that phrase that we've been referring to.
Well, our position is, Your Honor, it's standalone. This is if the court reaches a decision that it would be ineffective, that is a remedy, a tool that the court has to affirm the legislative intent.
Thank you.
Thank you.
All right, Judge Howe, any questions for the state?
Good time, Chancellor.
All right. Thank you. We'll
Thank you, Your Honor.
allow everyone to have a rebuttal opportunity. I'm going to turn first to Ms. Bussell and ask for your rebuttal to the state's argument. And I would also invite you, just to make sure we've covered all bases, to address the consolidation clause and the exemption clause, if there is anything in either of those arguments you would like to highlight.
Yes, and Chancellor, I also invite you to remind me of that. If I fail to do that, I have a sticky note, but I have multiple sticky notes, so I don't want to forget anything. So I will start first by addressing some of the state's arguments as to justiciability. One of the things that the state was addressing in the context of that argument was whether the state had conceded that 1B is unconstitutional. And I agree that at the temporary injunction phase, the state defended the whole act. That's accurate. But what the state did at the temporary injunction phase is, of course, completely irrelevant to what they did at the summary judgment phase. And in the state's response to Metro's summary judgment motion, there is no argument that 1B is constitutional. Instead, the state concedes that 1B is moot. The state concedes that 1B should be elided from the statute, which necessarily means that it's unlawful. And while the state contends that it has not stipulated to unconstitutionality, it certainly has not defended against unconstitutionality. So we would submit from a procedural perspective, they have waived any such argument that the act, that 1B of the act is unconstitutional. The state instead argues only that 1A creates a standalone cap that can be enforced notwithstanding the court's elision of 1B. The state also argued that subsection 1A, which sets the cap as further provided in this section, is not moot because of the existence of subsection C. And again, this was just sort of reiterating their argument that A and B go together to address what happens in existing metropolitan governments, and then C addresses what happens in future metropolitan governments. By making this argument, the state is effectively conceding that A and B are read together, that they operate together to dictate, or they operate together to force a mandate on Metro Nashville to reduce the size of its council. And as Chancellor Moskal certainly recognizes, Metro Nashville is the only council that is the only government with a council over 20, and therefore would be the only government affected by that mandate. And then the state goes on to say the court must elide consistent with legislative intent. And we couldn't agree more with that statement. But the state is necessarily asking you to ignore legislative intent in making their argument. They repeatedly ignore the qualifier as further provided in this section. And instead, they actually argue that the court should take it out altogether. I want to address that in a moment, but first I would ask the court, take a look at section 2. Section 2 of the act is a beautiful illustration of the legislative intent. There, the hundreds of municipalities that the state contends are affected by this act are great evidence of the legislature's intent to set a standalone cap in section 2 that applies to municipalities. And while the state argues that subsection 1A of the act also sets a standalone cap, the plain language of the act establishes that as further provided in this section does not exist in section 2. If the act accomplished what the state says it accomplishes, then section 1 would read just like section 2. Section 2 of the act contemplates the possibility of a municipality having a legislative body size greater than 20, and it dictates what happens in that scenario. But what is missing from section 2 is that qualifying language that creates that inextricable connection to the actual cap itself. And that's why we keep saying there's no standalone cap. That's the point of it. If you were creating a standalone cap, then the provision would read just like section 2 reads, with a period instead of a comma. The only way to adopt the state's interpretation of the statute is to elide the qualifying language. And of course, that is not permitted under the law. I would like to also address the state's argument that there are myriad Tennessee statutes that give courts the ability to enforce the law. That is a very broad statement that just simply misses the point of the argument. The state legislature has not conferred on Metro Nashville the authority to change its charter by legislation. And the Metro Charter Act makes clear that council size must be set by charter. So that begs the question, could Metro Nashville, under current law, alter the size of its council through any other method other than a charter amendment, which of course must be done only by referendum? And the answer to that question is no. There is no authority that would give Metro Nashville the ability to do that. The state cites Metro Charter section 14.05, and I would like to read a portion of that to the court. First of all, 14.30, sorry, I said that wrong. It's 14.30. 14.30 says And the title of that provision is severability of provision. But here's what it says. Each of the provisions of this amendment is hereby declared to be severable. And that provision, as we note in our briefing, is part of a larger portion of the Metro Code addressing general sessions courts. It doesn't address the Metro Charter generally. And then here's, I think, something that's even more significant. Even if the current provision in Metro's charter setting council size at 40 were preempted by the act, even if that were true, the act does not set a council district number. It merely sets a cap on the number. And there is nothing in state law or the Metro law that gives Metro Nashville the ability to set that number legislatively. So even if our charter that says we have 40 members, even if that's preempted, there's still no authority that would give us the ability to set a different number. And if the act cannot even be effectuated by its terms, then certainly the court could not hold that we are forced to reduce our council district number. And then I would conclude this particular argument by just reminding the court that it need not wade into these difficult, complex questions of what the Metro Charter requires or doesn't require, and could it set a number? Could it force the voters to take some action? The court need not address this question at all if it reads consistently with the plain language of the act that 1A and 1B necessarily go together. They're not severable from one another. And as a result of that, the unconstitutionality of 1B necessarily flows over into 1A. The legislative purpose of this law was to mandate Metro Nashville to alter its council size as outlined in section 1B. As further provided in this section, necessarily mandates that conclusion. If the act were to permit that be done in any other way, then section 1 of the act would read just like section 2. It does not, and the court cannot ignore those distinctions. As to the local legislation clause claim, again, the state's argument ignores the plain language of the act. The state's position that subsection 1A is not local in form or effect requires the court to ignore the qualifying language as further provided in this section. Again, there is no dispute that 1B is local in form or effect in violation of the local legislation clause in the Home Rule Amendment. The state has effectively waived that argument by not responding to it. And the state has waived that argument by arguing that that provision must be elided from the statute. The only reason you elide things from statutes is when they are unconstitutional. And the only way to accept the state's argument that 1A is not local in form or effect is to find that as further provided in this section means absolutely nothing. And the court cannot adopt that interpretation. We agree with the state that the court must harmonize all of the provisions in the act. Everything in section 1, including that qualifier, and everything in section 2, which accomplishes what the state suggests section 1 accomplishes, but without that qualifying language. The state's argument necessarily renders multiple provisions of this act meaningless in violation of statutory interpretation principles. Next, I'll address the argument that the state suggests that 1A requires other metropolitan governments to maintain compliance. That is, if at some point you want to change this, if at some point you want to do something different, you've still got to comply with that 20 member cap. I completely agree. The problem with this argument is that's not accomplished through 1A. That's accomplished through 1A as further provided in subsection E. In subsection E, which applies to everybody and is not challenged in this case, it makes clear that any metro government that wishes to alter its council size must comply with that cap. Metro Nashville has not challenged that provision. So as we stand here today, barring some challenge, Metro Nashville would have to comply with that provision. So maintaining compliance with that cap is accomplished through E, not through A as a standalone cap. In fact, as further provided in this section, again, that's what creates the cohesive flow between the cap in A and all of the circumstances in which that cap could arise. Certainly, the court should uphold the constitutionality of an act wherever possible. The problem is that cannot be done consistent with the legislative intent. And the legislative intent here is dictated by the plain language of the statute. We have argued and defended lots of cases involving constitutional challenges, and I can say this is the first that we have seen the state not lead with the argument that the plain language controls. There's a reason for that, because the plain language is damning to their position. The state also argues that elision is a flexible concept. Well, it's not favored. I do know that. It's not favored in the state of Tennessee. And it certainly does not permit the court to elide provisions, to rewrite statutes, in fact, which is what you were being asked to do, to avoid legislative intent. And that's precisely what the state is suggesting. The state cannot, well, the court cannot. The state should not ask this court to strike through provisions merely to avoid those consequences. And that's what the state is asking you to do. The state is not asking you to just elide 1B. The state is saying, take out that qualifier, because as Chancellor Bryant touched on in her questions, the state says that qualifier is rendered meaningless. If you take away 1B, then this language no longer means anything. That's precisely our argument. The two are inextricably intertwined. If, as the state argues, that qualifying language is rendered ineffective by striking 1B, and that you should just take it out, then the state is necessarily conceding that the language turns on one another. And it makes sense. It's completely consistent with the words on the page. 1A creates a cap as further provided in 1B, and 1C, and 1D, and 1E. And to strike through that language would be to rewrite the statute. As to the findings of fact, Chancellor Moskal, I have my colleagues in the room reviewing those, and they have assured me that there is nothing in those conclusions or findings of fact that we would not agree with. As Chancellor Moskal astutely recognized, some of those are no longer relevant given the expiration of the timelines and our concession that we aren't challenging the council member term or the council member term portion of the statute, which again is no longer relevant. So some of those would not be relevant to the ruling in this case, but we certainly have no issue and agree with all of the other findings. We would add, however, that we believe the case can be decided on issues of law without having to find any facts. And so that's why our statement of undisputed material facts, and I presume the states as well, are so limited.
And thank you. We'll certainly focus on that. One thing that I had noted, and I would just like clarification, Metro's charter was approved by referendum vote of the voters in the city of Nashville and Davidson County in June 1962. And it became effective, we stated in our temporary injunction, it became effective in April 1963. But I note in your statement of undisputed facts, that year is incorrect, I think. You said April of 1962. So was it by referendum vote, did that approve it back to April of 1962 when the Charter Commission approved it?
That the charter was not made retroactively effective. So to the extent, I think that's a typo.
In your statement of facts?
Yes, the charter was I'm looking back. Yeah, the charter was approved by referendum in June of 62, which means that it was made effective in April of 1963.
Okay, I just wanted
I
to make sure.
apologize for that confusion.
We had some inconsistencies there.
Yes. Thank you for catching that.
That's minor. Just wanted to make sure. Thank
That is
you.
correct. All right, and I saw my sticky notes, so I'm going to talk about the consolidation clause and the exemption clause briefly. So as to the consolidation clause, I would note just a couple of things. I don't want to just regurgitate what's in our briefing, but I would note that the Home Rule Amendment, I think this is important. The Home Rule Amendment contains plain language that is consistent with the argument that the state cannot, through legislation, retroactively unwind those sort of foundational components of a metro charter. If you take a look at Article 11, Section 9, the Home Rule for Cities clause is in paragraph 5 of that provision. And it's helpful to contrast the phrasing there with the phrasing of the consolidation clause. In paragraph 5, again, addressing home rule cities, which we are not. We are a consolidated government, which is a type of home rule, but certainly different. We're this unique creature under the Constitution. But for a home rule city, it says, any city adopting home rule may amend its charter to set forth its powers and structure subject to acts in general law. The consolidation clause, by contrast, in paragraph 9, contains no such qualifier. Again, we keep talking about qualifiers here, but those words must be given meaning. And so the consolidation clause certainly treats that concept differently. We would also argue that there is a difference between a state law provision that merely affects metropolitan governments and one that undermines the very foundation that formed the consolidation itself. And it's important to go back to what the Metro Charter Act originally said. And in the Metro Charter Act, consolidated governments were required to do certain things in their initial charter. And one of those things was to establish their council. They have to call it a metropolitan council, for example. They have to set a number of council districts. And so in state law, that requirement, that responsibility was given to the government itself. And so that is a foundational component of the government's creation, and we submit is beyond the power of the General Assembly to dismantle. There is simply a difference between limiting a metro government's power through general law and completely undermining its foundation. And that is where this act goes awry. Permitting the General Assembly to retroactively unwind the very charter provisions that the General Assembly said we must adopt would render the consolidation process meaningless. I would like to bring to the court's attention, the state has cited County of Shelby versus McWhirter a number of times. That case is not about consolidated governments. So let's just start there. It's about home rule county, a home rule county, not a consolidated government. It's also important to recognize that in that case, the court actually distinguishes a different opinion, Robinson versus Briley, which one of the parties had presented to the court as supporting its argument. And the court distinguishes Robinson versus Briley on grounds that it addressed a consolidated government. So certainly, while not necessary to the ruling, I think what this is helpful to illustrate is the court's repeated recognition that consolidated governments are different. And again, that would also take us back to that language in the Constitution that doesn't say that consolidated governments are subject to the general law provisions like it does for home rule cities. As to Chattanooga-Hamilton, I would just say this. Chattanooga-Hamilton should be confined to its facts. Chattanooga-Hamilton involved a consolidation of it involved two private acts, one that created a hospital authority and one that amended that prior private act. And those facts are vastly different from what this court is considering. There, the Supreme Court declared that the initial private act creating the hospital authority constituted a consolidation under the consolidation clause. That authority was created to provide public health services pursuant to police powers. It certainly did not involve something as foundational as the consolidation of a city and county government, which is what Article 11, Section 9, that's really the heart of Article 11, Section 9. And the court stated in dicta in that case that a referendatory vote is only required for acts that accomplish a consolidation, not for acts amending or repealing a consolidation. And this is the language that the state keeps returning to. It is not clear. I've read that case many, many times, and it is not clear to me at all what the intended scope of that language was. But what I can tell the court is that that case did not involve a repeal of a it didn't involve a repeal of anything, for what it's worth. So that would have been dicta even under its own facts. It certainly doesn't apply here, where you're talking about effectively repealing the foundational structure of a metropolitan government. That case involved private acts that were passed with some form of local approval for both of them. The acts certainly did not raise the same type of sovereignty concerns as this case. And so we would submit, as a trial court, this court should limit that case to its facts. If the Supreme Court wants to reverse Chattanooga Hamilton at some point, it's certainly within its ability to do that. And we do not think that is outside the realm of possibility when applied to this circumstance. But that case has nothing to do with the type of threat to sovereignty that is at stake in this case. I will conclude on the consolidation clause by highlighting this, because I think this really is the heart and soul of our argument. If the General Assembly can do this, if the General Assembly can tell a local government, a consolidated government, you know what? No way, no, we're not going to do that anymore. You've got 40. We don't like that as a policy matter. So we're gonna set a different cap. And you have to, it's basically a do-over. You have to start over again, despite the fact that that number was set by essentially inconsistent with the instruction that the General Assembly gave us in 1962. Do it again, pick a different number. What would keep the General Assembly, for example, from cutting the size of the Metro Council from 20 to 15 a year from now? Nothing. What would keep the General Assembly from cutting the size of a council from 20 to 15 the week after a consolidation? Nothing. Nothing would prevent that. And these are all logical extensions of the state's argument that the act does not violate the consolidation clause. In fact, what would keep the state from unwinding the consolidation entirely? You know what? We've changed our mind. We don't think you should be able to consolidate. We don't care that we told you in the Metro Charter Act that the voters get to make that choice. We don't care that the 1953 Constitutional Convention was designed to prevent this very type of intrusive local legislation. We don't care because we think you should do it differently. The state sort of concedes in their papers that that would be absurd, that it would be absurd to suggest that the General Assembly could unwind a consolidation altogether. In fact, they say that's really all this prevents. That's really all the consolidation would prevent. Otherwise, the legislature can do whatever it wants. But that is a necessary extension of the argument. That's the problem with it. It has no end. There is no end to the argument. That is not what the delegates to the 1953 Constitutional Convention envisioned. They convened that process to protect local governments from that type of overreach. And the building blocks that the General Assembly put in the hands of voters in the Metro Charter Act should be protected. So let me address the exemption argument and this arises out of the constitutional provision in Article 7, Section 1. So this claim arises under the second, third, and fourth sentences of that provision, and I'm going to turn to it. And this is, I should have said this. This is in paragraph 2 of Article 7, Section 1. The third sentence of paragraph 2 limits the size of county legislative bodies to 25. And then the fourth sentence explicitly exempts metro governments from having a county legislative body as described in this paragraph. When adopted at the 1977 convention, Metro Nashville had already been operating with a 40-member council for 15 years. The constitutional intent here was to exempt metro governments from that 25-member ceiling. In the State Ex Rel Manor v. Leach case that we discuss in this portion of our briefing, the court makes clear that the purpose of this was to exempt metro governments from Article 7, Section 1 government. The point was to exempt them from all of it. That exemption is not to basically create less autonomy for metro governments. That would defy the purpose of the Constitutional Convention and the amendment altogether. The purpose was to create more autonomy for metropolitan governments. Now, the state defendants acknowledge the constitutional limit, right? They say, oh, we agree that this sets a 25-member ceiling on county legislative bodies. But then they say nothing prohibits the General Assembly from doing that. So effectively what they're saying is, even if we were to agree with you that that's not permitted by the Constitution, nothing in that provision says the General Assembly can't change it later. And again, this completely ignores the purpose of the constitutional protection. The constitutional provision was designed to give metro governments more autonomy, not less autonomy. And if the purpose of the provision by creating an exemption wasn't to prevent the General Assembly from altering that number later, then what possibly would the provision mean? What could it mean other than you don't get to do on the back end what you can't do on the front end? It doesn't call out the General Assembly by name, but it says that metro governments are exempted from having a county legislative body as outlined in this paragraph. It makes no sense, again, and undermines the entire purpose of consolidation if the General Assembly can do on the back end what the Constitution says that it can't do on the front end. There is no plausible reading of the paragraph's third and fourth sentences in conjunction with each other than Metro Nashville's position that metro governments are exempt from having that county legislative body tinkered with in this way. I want to conclude with this. I would like to return to Chancellor Moskell's question. What does the court do with the phrase as further provided in this section? Because here again, we've talked about a lot of stuff today that the court simply need not wade into, because the answer to that question dictates the outcome of this case. What must the court do with that phrase? It must enforce it. It must enforce it as written, as intended, as the plain language dictates. The chancellor appropriately recognized that the court can't ignore it. But that's exactly what the state is asking you to do. They go so far, in fact, as to say, take it out altogether. And by making that argument, they have effectively conceded that 1A and 1B go together. Tennessee Code annotated 13110 does allow you to sever provisions that would be rendered ineffective by unconstitutional provisions. I completely agree. And the state has conceded that 1B is unconstitutional. And by arguing that 1A would be ineffective without it, they have effectively conceded that 1A falls as well. They are not severable. They must be read together. To adopt the state's interpretation would be to rewrite the code. And we would ask the court for those reasons to find that this case is no longer justiciable because this act no longer mandates Metro Nashville to alter the size of its council. Thank you. I think you're muted, Chancellor Moskal.
I'm having a, I hope you can hear my HVAC system right now. It's chirping loudly. So I'll try and talk over it. Any questions, Chancellor Bryant or Judge Howe? For Ms. Bussell?
No questions.
All right, we'll move to the state's rebuttal. And Mr. Tift, before I hear last from Mr. Simons, do you have anything to add? I don't want to ignore you. You've been very patient. All right. The state, you may proceed with your rebuttal.
Thank you, Your Honor, and I'll be brief on this. I just wanted to point out a couple of points. First of all, with regard to the discussion of the Chattanooga Hospital Authority case Ms. Bussell was referring to, that case did not deal with metropolitan governments, but it did deal with this consolidation clause and what the scope of the authority is and how it's interpreted. And I think to the extent that that case deals with a interpretation of the constitutional provision, it does apply to this particular situation because it relies on the same constitutional provision. The other thing I was going to mention is this concept of severability. And the Metro Nashville has taken in its brief and at the oral argument this idea that these are inextricably intertwined, 1A and 1B, and 1A must fall. The position that the state is taking is consistent with the court's order in its temporary injunction hearing. I mean, the court in that hearing and in its decision, in order to enjoin the enforcement of 1B, but not to enjoin the enforcement of 1A, said, and I quote on page 32, the provisions of section 1B are not so intertwined with a generally applicable seat cap on metropolitan legislative bodies that the court sees any issue with effectuating the severability clause. Therefore, they went on. So clearly, the position the court has seen in light of the rules of construction and how the interplay between these various sections support the state's position, which is 1A and 1B are severable, and the mere fact that 1B, if the court finds it's unconstitutional, does not make 1A likewise unconstitutional. And so we think the position we're taking is the reasonable one in light of all the case law and the rules of statutory construction and the doctrine of elision. So I would suggest, Your Honor, I rest with basically mentioning again that we seek to have our motion for summary judgment granted, dismissing the plaintiff's complaints.
All right, thanks to the briefing and to all counsel as well for your arguments here today. Were Chancellor Bryant or Judge Howe, do you have anything you would like to add or any questions?
Chancellor, I don't. Thank you, though.
All right, thank you.
Nothing else for me. Thank you.
All right, that concludes our hearing today. In this case, we will take the matter under advisement, all of the motions. Thank you for the well-briefed arguments and your presentations today. It was very helpful, and everyone have a good rest of your day. We will disconnect the meeting. Thank you.
Thank you.
Thank you.